on Rule 116, and we hope to finish everything this afternoon. So Rule 116 pertains to arraignment and plea. So how is an arraignment and plea made? So Section 1 of your Rule 116 provides that the accused must be arraigned before the court where the complaint or information was filed or assigned for trial. So the arraignment must be done kung asa na file ang case. The arraignment shall be made in open court by the judge or clerk by furnishing the accused with a copy of the complaint or information, reading the same in the language or dialect known to him, and asking him whether he pleads guilty or not guilty. The prosecution may call at the trial witnesses other than those named in the complaint or information. So, when we talk about arraignment, mao nang time nga basahan ka sa imuhang kaso, no? So there you will be asked, how do you plead? Is it guilty or not guilty? Okay, so that's what happens during arraignment. I think kita na mo ana in the movies, no? And for police officers, permi na ni sila maka-witness of arraignment. And then paragraph B provides that the accused must be present at the arraignment and must personally enter his plea. Both arraignment and plea shall be made in record, but failure to do so shall not affect the validity of the proceedings. So, kailangan na agad na si accused, di pwedeng magpa-SPA ra siya, o maingon siya dito in the SPA, I hereby authorize so and so to enter my plea. It cannot be done. So, during the arraignment, dapat present siya, personally present. And then when the accused refuses to plead or makes a conditional plea, ang plea of not guilty, mao na ibutang diha sa record. Kay di siya motingog or condition na lang iyang paghatag sa iyang plea, not guilty ang mabutang. And then when the accused pleads guilty but presents exculpatory evidence, his plea shall be deemed withdrawn and a plea of not guilty shall be entered for him. Okay, that's the rule. And then when the accused is under preventive detention, his case shall be raffled and its records transmitted to the judge to whom the case was raffled within 3 days from the filing of the information or complaint. The accused shall be arraigned within 10 days from the date of the raffle. The pretrial conference of his case shall be held within 10 days after arraignment. So mauna siya ideally ang rule, but under the continuous trial, no, usa na. After the arraignment, lahos na ang pre-trial conference. So para dali na lang, after the arraignment, okay, let's proceed to the pre-trial. And then after ana, mag-set the dates for the trial. And then the private offended party shall be required to appear at the arraignment for purposes of plea bargaining, determination of civil liability, and other matters requiring his presence. In case of failure of the offended party to appear despite due notice, the court may allow the accused to enter a plea of guilty to a lesser offense which is necessarily included in the offense charge with conformity of the trial prosecutor alone. Okay, so pwede na. And then unless a shorter period is provided by special law or Supreme Court circular, the arraignment shall be held within 30 days from the date of the court acquires jurisdiction over the person of the accused. The time of the pendency of the motion to quash or bill of particulars or other causes justifying suspension of the arraignment shall be excluded in computing the period. So basically mo na rule, but in reality, di kayo siya matuman because of a lot of cases nga pending sa korte, no? Pero uban gyud nga courts nga mutuman gyud aning period provided for by the rules. Now, unsa ning arraignment gani? Arraignment is a formal mode and manner of implementing the constitutional right of an accused to be informed of the nature and cause of the accusation against him. Its purpose is to apprise the accused why he is being prosecuted by the state, and as such, it is an indispensable requirement of due process, and it cannot be regarded lightly or brushed aside peremptorily. Okay? Now, doon na ba yung mga options ang akusado before siya mo-enter o plea and before the arraignment? So before the arraignment and plea, ang accused may avail of the following remedies, no? Una kaning gitawag nato bill of particulars. Unsa man ning bill of particulars? When we talk about bill of particulars, mao ni siya it's like a motion clarifying the prosecution kung unsa man gyud imong gi-charge sa ako So the motion shall specify the alleged defects of the complaint or information, and it shall specify the details desired, okay? So if the accused, for instance, finds the information defective as it bears only the month and the year of the incident complained of, ang iyang buhaton is to file a bill of particulars as provided for in the rules of court before he enters his plea. And failure to do so would amount to a waiver of the defect or the detail desired in the information. So, kung naa kay nalibgan, doon na kay gusto i-clarify, you have to do it before you enter your plea, okay? And you have to file it as a motion of, or as a motion for bill of particulars, okay? Another remedy that you could actually do is suspension of arraignment, okay? So, unsa may mga instances nga pwede kang mo-ask og suspension for arraignment. Una, kanang the accused appears to be suffering from an unsound mental condition which effectively renders him unable to fully understand the charge against him and to plead intelligently thereto. So, pwede na siya nga mo move sa for the suspension of arraignment. And here, they can ask for the examination, mental examination of the accused. And then another instance, if there's a prejudicial question, okay, kung may prejudicial question must be resolved first before the arraignment may proceed. Also, kung there is na ay petition for review of the resolution of the prosecutor, it could happen sometimes, no, na ang akusado wala siya na kontento sa desisyon sa prosecutor. So they would file a petition for review of the resolution of the prosecutor before the Department of Justice or the Office of the President. Okay, so the period of suspension here shall not exceed 60 days counted from the filing of the petition with the reviewing office. Okay. And then another thing is kini atong gitawag og motion to quash, which we will be discussing later on, no, extensively. And also, you can challenge the validity of the arrest or legality of the warrant issued or assail the regularity or question the absence of a preliminary investigation of a charge. So what naka-experience ko ani kani, I would question the absence of a preliminary investigation of a charge. My client was charged with rape through sexual assault, and you know man in your preliminary investigation that preliminary investigation is basically mandatory for cases with an imposable penalty of 4 to 1. So sexual assault is above 4 to 1 man. And then here, my client was not given the opportunity to file his counter affidavit during the preliminary investigation. So he was issued an information and issued a warrant of arrest. He was arrested. So before his arraignment, I filed a motion for the conduct of a preliminary investigation on the ground that there was absence thereof, no, kay wala siya natagaig chance nga mo appear during the preliminary investigation, and luckily it was granted by the court and still pending, hopefully lang favorable on the part of my client. So those are the options that the accused may avail of before entering his plea, no, during the arraignment. Now, let's go to section 2. I will be discussing only the salient points ha, kay para mahuman gid nato siya. So section 2, plea of guilty to a lesser offense. So mo ning gitawag nato plea bargaining, no. At arraignment, the accused may, with consent of the offended party and the prosecutor, may be allowed by the trial court to plead guilty to a lesser offense which is necessarily included in the offense charge. So, importante kay na necessarily included in the offense charge. So after arraignment but before trial, the accused may still be allowed to plead guilty to said lesser offense after withdrawing his plea of not guilty. And no amendment of the complaint or information is necessary. So in our jurisdiction, the plea bargaining has been defined as the process whereby ang accused and the prosecution would work on a mutually satisfactory disposition of the case subject to court approval. So kita mo sa siguro mo na sa mga movies, the prosecution and the accused would talk, and then unsa man gusto ka mo plead guilty to a lesser offense, mao ni akong proposal nimo. Yeah, the accused would say, okay, I will bring this to my client, and then later on magstura po sila balik, okay, is it accepted? Okay, if it's accepted by both parties, they would they would bring it to the court and the court would approve it. If it's approved, mas labing maayo, okay? It usually involves the defendants pleading guilty to a lesser offense or to only one or some of the counts of the multi-count indictment in return for a lighter sentence than that for the graver charge. And you have to remember that it must be with the consent of the offended party and the prosecutor, okay? Unsa may mga requirements ana. So at the arraignment, the accused may plead guilty to a lesser offense and the court shall allow the plea provided the following requisites concur. Lesser offense is necessarily included in the offense charge. Dili pwede na the offense the offense committed was unsa may example ha. Let's say the offense committed was homicide and then you would plea bargain to serious physical injuries. Di pwede. Homicide, the element there is na namatay. So di pwede, di ba? Pwede if the charge is serious physical injuries and you would plead guilty to a lesser offense, let's say slight physical injuries or less grave, less serious, di ba, nga physical injuries. So pwede na. Okay, it is necessarily included in the offense charge. And the second is the plea must be with the consent of both the offended party and the prosecutor. However, no giklaro man to nga the consent of the offended party will not be required if the said party, despite due notice, napadadaan siya notice, dili siya maka-appear or wala siya ni-appear during the arraignment. Okay? Under the under the revised guidelines for continuous trial of criminal cases, kaning mga victimless crimes, no, kanabitang walay offended party, the presence of the arresting officer in court is required so he may give his consent to the conformity or with the conformity of the prosecutor to the plea bargaining. So thereafter, the judgment shall be immediately rendered in the same proceedings. Example ka na mga drugs cases, wa man ay private offended party. So basically, ang presence sa arresting officer mo gi-require sa court to give his consent, okay? So the consent of the offended party will not be required if the said party, despite due notice, fails to appear during the arraignment. Okay, balikon ta na nga although consent is necessary, but if despite due notice, unsa man ang due notice? Gipadadaan siya notice and it was proved that nga na-receive niya, but wa siya ni appear. So, kana, dili na na-require sa korte because he was given notice but he failed to appear. Okay? And then, further, niingon pod ang revised guidelines for continuous trial of criminal cases, no? It required that after plea bargaining, judgment shall be immediately rendered. And then the relevant provision declares that if the accused desires to enter a plea of guilty to a lesser offense, plea bargaining shall immediately proceed, provided the private offended party in private crimes or the arresting officer in victimless crimes is present to give his or her consent with the conformity of the public prosecutor to the plea bargaining. And then thereafter, the judgment shall be immediately rendered in the same proceeding. Okay? So, timan anak ninyo. Uso kaayo ni in drugs cases. And if you could remember, sa una, sa drugs cases, di na allowed ang plea bargaining. Okay? Niingon ang revised guidelines for continuous trial of criminal cases nga ang plea bargaining daw does not apply to drugs cases. And according to that particular provision, any person charged under any provision of this act, regardless of the imposable penalty, shall not be allowed to avail of the provision on plea bargaining. Maunay provision sa una nga naa sa RA 9165, particularly in Section 23. So, luoy kitong mga nadakpan of drugs, no? Kaya di gud na sila ka plea bargain. But, the Supreme Court declared this particular provision as unconstitutional in August 14, 2017, no, in an order or in a decision handed down by the Supreme Court in the case of Estepona versus Lobrigo. Ingon ng court nga kaning Section 23, RA 9165, which prohibits plea bargaining in drugs cases, is actually unconstitutional, niingon ng Supreme Court. The ruling stemmed from a petition for certiorari and prohibition filed by the accused challenging the constitutionality of Section 23 when his motion to be allowed to plead guilty to a lower offense of the possession of drug paraphernalia from illegal possession of dangerous drugs was denied by the trial court. So in ruling against the constitutionality of the said provision, the court explained that plea bargaining is a matter of procedure. Ha? Sige, yung Supreme Court, it's a matter of procedure. And the power to promulgate rules, if you can still recall in your consti karon, di ba? In your, I think that's Article 8. Yeah, Article 8 of your Constitution, nga ang power ko no to promulgate rules of pleading, practice, and procedure in the courts is in the court's exclusive domain and no longer shared with the executive and legislative department. So in essence, the Supreme Court, the provision is unconstitutional because it contravenes the rulemaking authority of the Supreme Court under Article 5 of the under Article 8, Section 5, Paragraph 5 of the 1987 Constitution. Dali ra ka na nyo meron dumana ka ng rulemaking power sa SCK. 558. Pwede said 855. Article 8, Section 5, Paragraph 5. Okay? And then the Supreme Court and Bank issued on April 10, 2018, the adoption or an administrative matter adopting the rules on plea bargaining framework in drugs cases. So karon if naka-observe mo in the courts na ay particular grams nga pwede ka mo plea bargain, okay? Di pud tanan. So, ningon ng Supreme Court, di man na nimo right legislature and executive to say that the accused cannot avail of the plea bargaining privilege under the rules kay kana siya rule make it's a matter of procedure. So kung procedure kami gid ana ang naay power dili kamo. So niingon ng Supreme Court that's unconstitutional because you contravene the rulemaking power of the you contravene the provisions on the rulemaking power of the Supreme Court. So himan ilang na. And then plea of guilty to capital offense. So when the accused pleads guilty to a capital offense, the court shall conduct a searching inquiry into the voluntariness and full comprehension of the consequences of his plea and shall require the prosecution to prove his guilt and the precise degree of culpability. The accused may present evidence on his behalf. So just because ni plead siya guilty to a particular capital offense, automatic na no, really pa. Ang korte will really conduct searching inquiry, okay? And then further, when the accused pleads guilty to a capital offense, it is not proper for the court to immediately render judgment on the basis of the guilty plea. Instead, the court is mandated to perform the following. Muna, kung giingon gini ha, mag-conduct of searching inquiry, and the purpose of which is to ascertain the voluntariness of the plea and to ascertain whether or not the accused has full comprehension of the consequences of his plea, okay? And then to require the prosecution to prove the following. Una, the guilt of the accused, and then the precise degree of his culpability, and to ask the accused if he wishes to present evidence on his behalf and be allowed to do so if he desires, okay? So may pasabot anang searching inquiry. According to the Supreme Court, wa gyud na definite and concrete rule no kung unsaon sa judge pag-conduct sa searching inquiry. Pero ning come up ta og guidelines in conducting such inquiry. So niingon ang Supreme Court, una, i-ascertain nimo gikan sa accused kung giunsa siya pag brought into the custody of the law. Ikaduha, whether he had assistance of a competent counsel during the custodial and preliminary investigation. Ikatulo, under what conditions man siya na detained and interrogated during the investigation. So this is accordingly intended to rule out the possibility that the accused has been coerced or placed under a state of duress, either by actual threats of physical harm coming from malevolent quarters or simply because of the judge's intimidating robe. So nindot gid pagka-istorya sa Supreme Court no, sa Supreme Court masulti. Nindot gid paminaon kaayo. Nindot gid kailang mga language. And then also ask the defense counsel a series of questions as to whether he had conferred with and completely explained to the accused the meaning and consequences of a plea of guilty. Importante na. And then elicit information about the personality profile of the accused, such as his age, socio-economic status, and educational background, which may serve as a trustworthy index of his capacity to give a free and informed plea of guilty. Also, to inform the accused the exact length of imprisonment or nature of the penalty under the law and the certainty that he will serve such sentence. And then inquire if the accused knows this crime with which he is charged and fully explain to him the elements of the crime, which is the basis of his indictment. Observe ko ano, na one time ning, dili akong client, na one time ning plea of guilty to a capital offense, dugay kay human si judge because he really ensured nga kay bawo gyud ang akusado sa iyang gibuhat. And then all questions posed to the accused should be in a language known and understood by that accused, and then the trial judge must satisfy himself that the accused in pleading guilty is truly guilty. Then the accused must be required to narrate the tragedy or reenact the crime or furnish its missing details. So importante kaayo na, okay? Now, provisions on section 4, 5, and 6 are matters of reading. Kaning section 7 po, section 8, basahan ni ninyo. Also section 9 and section 10. Section 11, we've discussed this kaniha. And then let's now go to motion to quash. Motion to quash pod. Let's read together sections 1 and 2. Ang 1, nag-ingon, at any time before entering his plea, ang accused may move to quash the complaint or information. Basically, this is before arraignment, okay? Unsa may form and contents sa imuhang motion to quash, it shall be in writing, signed by the accused or his counsel, and shall distinctly specify its factual or legal grounds. The court shall consider no ground other than those stated in the motion except lack of jurisdiction over the charge or over the offense charged, okay? So unsa may mga grounds for the quashal of an information or a complaint? Okay, so unsa man na? First, that the facts charged do not constitute the offense. Ikaduha, that the court trying the case has no jurisdiction over the offense charge, that the court trying the case has no jurisdiction over the person of the accused. If you can remember, di ba? Katong mga elements for the exercise of valid jurisdiction, jurisdiction over the offense charge, jurisdiction over the person of the accused, jurisdiction over the subject matter, di ba? Jurisdiction over the territory. So basically, those are the grounds for the quashal of information and complaint, di ba? And then the officer who filed the information had no authority to do so. Example, katong mga crimes nga cannot be prosecuted official, ka-remember mo. And then if it does not conform substantially to the prescribed form, pwede na. And then katong gingon nga complete information must be substantial in form, di ba? And then that more than one offense is charged, except when a single punishment for various offenses is prescribed by law. At naginagipang discuss. So the criminal action or liability has been extinguished. Extinguished na di ay. O, di ba? Iyan na di ay itong naservan or let's say ni prescribed na di ay. And then if it contains averments, which if true would constitute a legal excuse or justification, and then the accused has been previously convicted or acquitted of an offense charge, or the case against him was dismissed or otherwise terminated without his express consent. So kanay mo attach ang double jeopardy. Ato ning basahon together with section 9. Okay? Timan nga ang failure of the accused to assert any ground of a motion to quash before he pleads to the complaint or information, either because he did not file a motion to quash or failed to allege the same in the said motion, shall be deemed a waiver of any objections except those based on the grounds provided for in paragraphs A, B, G, and I. A, B, G, and I of section 3. Unsa tong A, B, G? A, katong do not constitute an offense. B, katong no jurisdiction over the offense. G, crime has already prescribed, can extinguish na. And then, sa to? I, double jeopardy. Okay? So, kung di ni mo na ang general rule is if you cannot file a motion to quash based on section 3, it's deemed waived, except kaning mga grounds provided for in A, B, G, and I of that particular section. So, bisan pag di mo na ma-raise before the arraignment, before he enters his plea, okay? you can still file the same if ang imong ground is in A, B, G, and I of Section 3 of this rule. Okay? So again, unsa to, although di ni mo na ma-raise nga grounds, no? Ang naa sa motion to quash and they are considered waived. Ang kaning mga objections in Section 3, A, B, G, and I are not deemed waived, no? Bisan pag di ka maka-raise anak before the arraignment. Unsa to una, ang A kay that the facts charged and constitute an offense. Ang B, that the court trying the offense has no jurisdiction over the offense charge. Ang G, kay criminal action has already been extinguished, and then double jeopardy in your I. Okay? So basically, that's the provision in Section 7 and 9. Okay? But remember that a motion to quash not based on any of the grounds provided for in Section 3 shall be deemed a prohibited motion under the revised guidelines for continuous trial of criminal cases. And to be deemed meritorious, the motion to quash must be based only on grounds mentioned in Rule 117, like, for example, katong atong gisgutan ganiha nga the facts charged would constitute an offense, lack of jurisdiction, extinction of criminal action or liability, or double jeopardy. So dapat kung mo-raise kag motion to quash, it has to be those that are provided for in Rule 117. Kung wala gani diha, your paper is deemed to be a prohibited motion, a mere prohibited motion. Okay? All right. Arita sa, that's it. Arita sa double jeopardy. Okay? Kanang provision on Section 7. Okay? Section 7, double jeopardy. So, unsa man ang double jeopardy? So, when an accused has been convicted or acquitted, or the case against him or otherwise terminated without his express consent by a court of competent jurisdiction upon a valid complaint or information or other formal charge subject in form and substance to sustain a conviction, and after the accused had pleaded to the charge, the conviction or acquittal of the accused or the dismissal of the case shall be a bar to another prosecution for the offense charge, or for any attempt to commit the same or frustration thereof, or for any other offense which necessarily includes or is necessarily included in the offense charged in the former complaint or information. So if I were you have to commit this provision to memory, okay? Para dali ra ninyong mahinumduman when you take the bar. However, the conviction of the accused shall not be a bar to another prosecution for an offense which necessarily includes the offense charge in a former complaint or information under any of the following circumstances. Una, the graver offense developed due to supervening facts. So bisan pa og primero ang i-charge ay muha serious physical injuries ra. Yan ay supervening facts na matay. So di ka pwede moingon na double jeopardy because the graver offense developed due to the supervening facts arising from the same act or omission constituting the former charge. Ikaduha, the facts constituting the graver charge became known or were discovered only after a plea was entered in the former complaint or information, or the plea of guilty to the lesser offense was made without the consent of the prosecutor and of the offended party, except as provided in Section 1F of Rule 116, and then any of the foregoing cases where the accused satisfies or serves in whole or in part the judgment, he shall be credited with the same in the event of conviction for the graver offense. Okay? So, ang kaning double jeopardy, no, makita ni nato sa Constitution, in your Philippine Constitution. Niingon dira ang Section 21, Article 3, Bill of Rights, no, of the Philippine Constitution, nga no person shall be twice put in jeopardy of punishment for the same offense. If an act is punished by a law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. Okay? When we talk about jeopardy, in legal sense, this is actually the danger of conviction and punishment which defendant in a criminal action incurs when a valid indictment has been found. Be it noted that Philippine Constitution does not prohibit placing a person in jeopardy. What it prohibits is putting an accused in double jeopardy, in which he is put in danger of a conviction and punishment for the same offense more than once. Okay? And then further, the constitutional provision against double jeopardy guarantees that the state shall not be permitted to make repeated attempts to convict an individual for an alleged offense, thereby subjecting him to embarrassment, expense, and ordeal, and compelling him to live in a continuing state of anxiety and insecurity, as well as enhancing that possibility that even though innocent, he may be found guilty. Okay? Kaning Kaning double jeopardy, this is also known as the res judicata in prison gray. Okay, timanin ninyo ning gawas bitaw ni sa war. Unsa man ang res judicata in prison gray? Prison gray. We talk about prison gray. Prison ba niya? Gray, G-R-E-Y. Okay? So another term for double jeopardy is res judicata in prison gray. This is the right against double jeopardy, or the right against double jeopardy prohibits the prosecution for a crime of which he has been previously convicted or acquitted. Okay? Therefore, when we talk about double jeopardy, this presupposes that a first jeopardy has already attached prior to the second jeopardy. And then the first jeopardy has already been terminated either because the accused has already been convicted or acquitted, or the case against him has been dismissed or terminated without his express consent. Timan yun ang linya nga without his express consent. If despite the termination of the first jeopardy or danger, he is put in danger anew for the same offense as in the first, then double jeopardy would now arise. Okay? So this is the very situation prohibited by the Constitution. So if the accused has been acquitted of frustrated homicide, example, he can no longer be accused of the same offense or of an offense necessarily included in frustrated homicide, like attempted homicide. Similarly, a person convicted of attempted homicide can no longer be tried as a rule under the information for frustrated homicide against the same victim because the second offense includes the offense charged in the first. Okay? Nya, di man ipod na ninyo nga kanang double jeopardy, di na siya applicable in administrative cases. Okay? Di na applicable in administrative cases. Nga naman, kay when we talk about double jeopardy, required man na nga na valid indictment before a competent court niya after arraignment, meaning criminal case ni. Yan ang may arraignment. And then when a valid plea has been entered, and then when the defendant was acquitted or convicted, or the case was dismissed or otherwise terminated without the express consent of the accused. Okay? So timan it does not find application in administrative cases. All right? And then, what else? Okay, let's now go to Section 8, provisional dismissal. Okay, this is very simple, no? Provisional dismissal. So when we talk about provisional dismissal, a case shall not be provisionally dismissed except with the express consent of the accused and with notice to the offended party. Tanawa ka ni, na express consent of the accused and with notice to the offended party. Kaya nga naman, unsay may mo effect kung walay consent sa accused? Ma-revive pa ba na? Di na ma-revive because nanay double jeopardy. Okay? So we talk about provisional dismissal, temporary ra ang dismissal ani, okay? So pila may period para ma-revive nimo ang usa ka kaso nga provisionally dismissed. So in provisional dismissal of offenses punishable by imprisonment not exceeding 6 years or a fine of any amount or both, it shall become permanent 1 year after the issuance of the order without the case having been revived. So after 1 year, no, the from the dismissal of the case, di na mo ma-revive. Permanent na ang dismissal. With respect sad to offenses punishable by more than 6 years, ang provisional dismissal shall become permanent 2 years after the issuance of the order without the case having been revived. Okay? So kaning concept sa provisional dismissal contemplates that the dismissal of the criminal action is not permanent and can be revived within a period set forth by the rules of court. Matoniin niya, kung not exceeding 6 years, 1 year, kung nakay 1 year to revive the case. Kung RTC cases, which katong mga offenses punishable by more than 6 years, ang imuhang period over which you can actually revive that case is 2 years. Okay? 2 years. So, kani nga new rule gi-conceptualize ni sa Committee on the Revision of the Rules and approved by the Court and Bank primarily to enhance the administration of criminal justice system and the rights to due process of the state and the accused by eliminating the deleterious practice of the trial courts of provisionally dismissing criminal cases on motion of either the prosecution or the accused or jointly, either with no time bar for the revival thereof or with a specific or definite period for such revival by the public prosecutor. So mo na gilikayan why mugna gid ni sa rules no gibutang gid ni sa Supreme Court sa rules nga dapat there has to be a period kung mag provisional dismissal naman lang gani kabutang yung time limit over which you can actually revive the case, okay? And then kaning second paragraph no, mao ning gitawag sa Supreme Court as the time bar rule. Okay? And this requires compliance with the requisites mandated by the first paragraph. Meaning, before this can be considered, kailangan do express consent sa accused onya it must be with notice to the offended party. Okay? Again, timan-ing without complying with the above requisites, the dismissal will not trigger the operation of time bar rule in the second paragraph of section 8, kaninga second paragraph. The case may thus be revived even after the period stated in the second paragraph, subject of course to the defense of prescription or the defense of double jeopardy if applicable under the circumstances. So, kailangan na express consent and with the notice to the offended party mo gina ang requirement. Okay? Fit na ta. Let's now go to Rule 118 and Rule 119, pre-trial and trial. Basically, very simple. Pre-trial, this happens before the trial, okay? Ang may tabuan maghisgot mo kung unsay, kung doon na ba'y plea bargaining, doon na ba'y mga stipulation of facts, o sa may mga angkuno ni mga facts. Mag-mark sa mo dire sa evidence during the pre-trial, mga exhibits, inyo nang pamarkahan di daan, and then you can also do the waiver of objections to the admissibility of evidence, and then modification of the order of trial. Let's say kung si accused niyon siya guilty ko, or mayon si accused self-defense, so siya maguna sa iyahang lawful defense. And then such matters as will promote a fair and expeditious trial for the criminal and civil aspects of the case. So basically, mo na mahitabo during the pre-trial, no? And then the trial proper. Muna na nga sugod na general rule mo sugod si prosecution mo present siya sa ebidensya, after anak mo rest siya and then the accused na pod. But before si accused mo present sa iyang evidence no, after si prosecution mo rest sa pag-present sa iyang case, dunay option si accused nga mo file og demurrer to evidence. Munay sikat kaayo sa court nga kasagaran buhaton no sa mga abogado no if they think that the prosecution fails to establish the elements of the crime. Okay? So, after the prosecution rest this case, kanus ama na considered nga ning rest na si prosecution sa iyahang kaso. Human na niya formal offer o niya pag-accept na ni judge, pag-render nag-order ni judge sa iyahang formal offer. Maingon naman din na siya nga with the admission of this honorable court of the formal offer of the evidence offered by the prosecution now rests its case. So after ana, diha na din musod ang chance sa akusado nga mo file og demurrer to evidence. So after the prosecution rests its case, the court may dismiss the action on the ground of insufficiency of the evidence on its own after giving the prosecution the opportunity to be heard or upon demurrer to evidence filed by the accused with or without leave of court. So, pwedeng ma-dismiss no on the ground of insufficiency of evidence. Una, pwede mo to proprio si judge and then iya lang pa-explainer or tagaag opportunity ang prosecution nga ma-heard ang ilahang case. And then pwede pod nga kaning demurrer to evidence filed by the accused. Okay? So if the court, mo ni effect ha, tanawa sa effect. Kung ang court would deny the demurrer to evidence filed with leave of court, tanawa ha, kung na leave of court, unya gi-deny sa court ang imong demurrer to evidence, ang accused may still adduce evidence in his defense. But kung ang demurrer to evidence is filed without leave of court, ano nang with leave of court without? Ito nang gisugutan sa una, no? Kanang ning file kag motion usa unya gitugutan ka sa judge, allow ka sa judge to file your demurrer. So you file a motion for leave to file a demurrer to evidence. If it is granted, and then you will be considered to have filed your demurrer to evidence with leave of court. If it's denied and you still file your demurrer to evidence, you will be considered to have filed your demurrer to evidence without leave of court. Unsa may mahimong effect ana? Kung ni-file kag demurrer to evidence without leave of court, ang accused waives the right to present his evidence and submits the case for judgment on the basis of evidence for the prosecution. Okay? So kung ma-deny imong demurrer to evidence nga walay leave of court, dili ka makapresent sa imuhang depensa. You are deemed to have waived your right to present your evidence. Okay? So ang pila man ka days before ka mo file og motion for leave, katuning demurrer to evidence with leave of court. Okay? The motion for leave of court to file demurrer to evidence shall specifically state grounds and shall be filed within a non-extendable period of 5 years after the 5 days after the prosecution rests its case. So the prosecution may oppose the motion within a non-extendable period also of 5 days. Okay mo, pa siya comment or opposition to the motion. So kung ang leave of court is granted, the accused shall file the demurrer within 10 days. The prosecution may oppose also within the similar period. So the order denying the motion for leave to file demurrer to evidence or the demurrer itself shall not be reviewable by appeal or by certiorari before the judgment. After ana, kung gideny imong demurrer to evidence, you will proceed. Kung with leave na, you will proceed to the presentation of the accused evidence. Matiman kung without leave of court na imong demurrer and it's denied by the court, you are deemed to have waived your right to present your evidence. Okay? Mao na siya ang mahimong, mao na risk go kung mo file ka og demurrer without leave of court. Okay? So I hope that's clear. Okay, so all right, it's very very short, no, when we talk about judgment remedies after judgment of conviction and provisional remedies. These are just matters of reading, no? So basaha lang ni ninyo. And I hope you will be able to answer the exams next week. So thank you very much, guys. Ambing mo.